As employers are updating handbooks and policies in the new year, many employers are considering implementing policies concerning the use of artificial intelligence tools. This makes sense given that AI tools are being used more and more by employers because these tools offer incredible benefits in the workplace. For example, they can improve efficiency, they can cut costs, and they can help with innovation. The use of AI tools in the employment decision-making process carries legal risk because these AI tools often have algorithmic decision-making software, and that algorithmic decision-making software can result in unintended bias being introduced into the employment decision-making process. If employers intend to use AI tools in the employment decision-making process, they should consider implementing the following 3 steps as part of their AI tool policies. First step is employers need to identify the technology. The reality is the use of AI tools is more prevalent than most people realize. The Equal Employment Opportunity Commission estimates that more than 80% of employers are currently using AI tools in the employment decision-making process. Common ways that these tools are used, they're used to identify applicants, interview applicants, evaluate employee performance, identify employees that are candidates for promotions, and to even train employees on a variety of topics. The second step is employers need to maintain human oversight over the technology. It's critical that employers make very deliberate choices about how they incorporate AI tools into the employment decision-making process. Human oversight is advisable from a legal perspective because it decreases the likelihood of unintended or unknown bias being incorporated into those decisions. But it's also advisable as a best practice because it decreases the likelihood that employees or candidates have a distrust in the process or its results because they know at the end of the day that a human being made the final decision. And the third step, employers need to vet the vendors, the tools that those vendors develop, and the data that those tools are trained on. The reality is that many tools are only tested by the vendors themselves with little, if any, independent oversight. As such, no one is looking into whether the tools are resulting in unintended or unknown bias. By vetting the vendor, employers can determine whether the vendors trained the software developers on ways to decrease the likelihood of bias in the design of the tool or implementation. They can also look as to whether the vendor consulted with experts on diversity in designing the tool. In vetting the tool itself, employers should look at how the tool has been used by other employers, its track record, its success, its failures, and the intended use cases. Employers should collect as much information as they can about how the tool will be used so that they can explain to employees and candidates about the role that the tool might play in the employment decision-making process. Employers should also make sure that they have sufficient information to understand whether the tool was designed in a way that accommodates for individuals with disability to avoid improperly screening out those individuals. Finally, employers need to vet the data. They need to understand the data that the tool was trained on and whether that data itself is biased. Using AI tools is becoming increasingly popular because it's inexpensive and it can greatly increase employee efficiency. As mentioned, using it to make employment decisions creates potential risk of unintended discrimination and bias, and that can be mitigated by taking the appropriate steps.